Call the court case, Chief.
All right. Thank you, Mr. Shima.
Thank you, Your Honor. May it please the court. The second case this afternoon is appeal number 123855 in the matter of David Philip Leon, matter and attorney discipline. The Office of the Disciplinary Administrator has reserved 3 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
Chief Justice Lukert and Justices, may it please the court, Kathleen Selsler-Lippert, Deputy Disciplinary Administrator, appears on behalf of the petitioner, Office of Disciplinary Administrator, present and ready for argument.
And Chief Justice Lukert and the justices, Bruce Swenson, appearing on behalf of the respondent, David Leon, who is also present in person, and we're ready to proceed with oral argument.
Thank you, counsel. Ms. Lippert, you may begin your argument.
This is an original action involving attorney discipline against David Philip Leon. The case is before the court after an evidentiary hearing. The allegations arose out of complaints from 4 different clients and respondents' work on their cases. All of the complaints related to respondents' failure to provide appropriate representation. 2 of the complaints included non-refundable fee agreements. Additionally, the respondent demonstrated a pattern and practice of failure to cooperate and failure to provide requested information. For example, the first investigator wanted to meet with the respondent in person for an interview and to review the file. The respondent was reluctant to meet with the first investigator. However, the first investigator insisted and scheduled an appointment in the respondent's office. When the investigator arrived, respondent was not there. However, he did arrive a little later. When the respondent did arrive, the next problem became apparent because the file could not be located. Respondent blamed his staff, and ultimately the first investigator asked respondent when it was found to provide it to the investigator. Respondent never did provide that file for that first investigation to that first investigator. The second investigator, who investigated several other complaints, also wanted to meet with respondent in person. The respondent was reluctant to meet with the second investigator in person and was successful in avoiding meeting the second investigator in person, and ultimately was interviewed by the second investigator over the phone. Another example of respondent's lack of cooperation is that he failed to provide timely written response. For instance, in one case, his written response was approximately 3 months late, and in another case, his written response was approximately a year late. A third example of his failure to cooperate is respondent's failure to provide trust or IOLTA account information to Investigator Delaney when it was requested. Additionally, during the course of over time, respondent did submit his attorney registrations from 2015 to 2019, and as required for all attorney registrations, respondent affirmed in these registrations that he was both familiar with Rule 115 and compliant with Rule 115. The evidence demonstrated that respondent's IOLTA account actually had not been used since 2009. The bank declared his IOLTA account dormant in 2010 after a year of inactivity. When investigators asked the respondent about his IOLTA account, he stated to Investigator Delaney that his IOLTA account was active, quote, to the best of his knowledge. This statement clearly was contrary to known facts. Respondent only deposited money in 2019, a decade after it was last used, and after Investigator Delaney told him that his IOLTA account was dormant. Respondent commingled unearned fees and failed to account for fees for a decade. Further, respondent failed to answer the first formal complaint that was filed. He did file an answer to the amended formal complaint. It was untimely and essentially on the eve of the formal hearing. No exceptions were filed by the parties, and the issue before the court today is the appropriate discipline. A few findings are important to highlight in support of the requested sanction of disbarment. The first investigation, client CF hired respondent to represent her in a criminal case. Client CF signed an information sheet for a non-refundable fee, paid respondent $500, which respondent then used to pay his mother's utility bills, as opposed to putting the unearned fees in an IOLTA or trust account. The second case, involving client TF hired respondent to represent him in a criminal case and paid respondent $2,500, which was not deposited into an IOLTA account, which had been dormant for nearly a decade at that point. At a point in time when respondent should have already provided a response to the complaint from client TF, respondent asked the client to send a letter to the Office of Disciplinary Administrator explaining that the complaint was a misunderstanding and wished to take the complaint back. The hearing panel found that this was intentional obstruction beyond respondent's pattern and lack of cooperation in other instances. The third investigation involved client GD. Client GD hired respondent for a criminal case. A condition of bond in client GD's case was no contact with his wife, who was listed as a witness. Client GD repeatedly and continuously asked respondent to file a motion to lift that no contact condition of bond. Respondent did not file a motion or try to get that condition of no contact lifted. Respondent's strategy in client GD's case was delay, and in fact asked for 12 continuances spanning 15 months. During that time, respondent's failure to try and get the bond condition modified exposed his client to new charges when respondent failed to file a motion to try and modify the no contact provision. The fourth and final case, the client WA was actually incarcerated and respondent was retained by the client's girlfriend to review 60-1507 issues. This fourth case, the respondent had the fee agreement signed by the girlfriend that stated or included a statement that said, no portion of this fixed minimum fee shall ever be returned to the client. This non-refundable language was included after respondent had provided his written response to the first investigation, where respondent acknowledged that a non-refundable fee agreement violated professional rules. Respondent again blamed his staff for this violation or this error. The respondent asked the hearing panel for probation. The hearing panel declined to consider probation because respondent had not implemented the terms prior to the formal hearing. My recommendation or request to the hearing panel and to this court is that the respondent should be disbarred. The panel's recommendation in their final hearing report was for indefinite suspension. The hearing panel did find a number of rule violations, at least 9 rule violations for competence, diligence, fees, safekeeping, expediting litigation, lack of cooperation, and professional misconduct, and failure to file an answer as required. And I would ask that this court adopt the hearing panel's findings of fact and conclusions for the rule violations. However, while the hearing panel did find aggravating factors, I would ask this court or argue to this court that the nature and extent of the aggravating factors in this case support disbarment. Respondent testified that he was under financial pressures and felt obligated to his family to help his family in some of their financial situations. And that was one of the reasons why respondent indicated that he used client CF's $500 retainer to pay his mother's utility bills. While this While the hearing panel found that his financial pressures and obligations to family was a mitigating factor, it also can be considered an aggravating factor as a selfish motivation. When a rule is violated, it's important to consider whether the attorney had an opportunity to self-correct. First, it should not be discounted that respondent's IOLTA account, as dormant or was dormant for a decade, is an aggravating factor in and of itself. But it's further aggravated by the respondent's opportunities and failure to take advantage of opportunities to correct that violation. So for instance, when Investigator King interviewed and spoke to respondent in February of 2019, respondent admitted to Investigator King that he didn't know how to handle money well and was not doing it correctly. There was an opportunity at that point, after respondent's recognition for his professional failures with respect to IOLTA or handling of money, to self-correct. Respondent didn't start using the trust account and didn't start correcting his violations in February of 2019 after that acknowledgement. In April of 2019, Investigator Delaney interviewed respondent about IOLTA and trust account and his bank records. Again, respondent acknowledged and was aware at that point in time that there were problems. However, respondent did not correct and start using his IOLTA account in April of 2019. It is concerning that even after this acknowledgement to investigators that he was not good at handling money and not handling money appropriately within professional rules, that when he renewed his or submitted his attorney registration in June of 2019, he again checked the box that where he affirmed that he knew and understood and was compliant with Rule 115. Clearly, that was not accurate. Another aggravating factor is that the flat fee, the inappropriate flat fee and non-refundable fee agreement language that was included in investigation with respect to CF. His written response in October 18, he acknowledged that that non-refundable fee language was not acceptable. However, when he had the last investigation, or the last client for the last investigation, sign a fee agreement in December of 18, just a couple of months later, he again included that non-refundable fee language. The respondent testified that the bank witness who testified at the evidentiary hearing about his use or lack of use of his IOLTA account, respondent indicated that he had actually used it, his trust account, more than what the bank witness testified to. A hearing panel member asked the respondent for clarity on that issue and use of his trust account, but respondent admitted that he hadn't really checked it. Yet again, it demonstrates his lack of concern to become compliant with the professional rules of conduct. This court has recognized that misappropriation of client funds is one of the most serious offenses an attorney can commit, and the sanction generally imposed has been disbarment. This hearing involves 4 separate clients, a trust account or IOLTA account that had been dormant and unused for over a decade, or for a decade, and respondents' failure to take advantage of opportunities after being interviewed by Investigator King or Investigator Delaney. Additionally, respondent exposed his client, particularly client GD, to harm when he did not file a motion to modify conditions of bond and lift the no contact order with client GD's wife. Additional aggravating circumstances would include prior discipline. Respondent had a 2012 diversion agreement where he admitted he violated 1.1 competence and failed to keep time records, which are violations that we see yet again before the court today. Respondents' repeated delay in investigations and particularly his refusal to comply with Investigator Delaney's request for trust account or IOLTA account records demonstrates a dishonest or selfish motive to protect himself from being held accountable for his misconduct. The extensive pattern of misconduct and multiple offenses also contribute and support a sanction of disbarment. Respondent's bad faith, I apologize, I'm out of time, and so I will stand down.
Thank you, Ms. Lippert.
Counsel, was there an instance that a client went to jail because she didn't know about a hearing in this case?
That is described in the stipulation. That client did not testify at the evidentiary hearing. Respondent refuted that to an extent and indicated that he had actually sent a letter to the client, but that was not what the client reported both in their complaint to our office.
There are other questions. Thank you, Ms. Lippert. Mr. Swenson?
Yes, Your Honor, Honorable Chief Justice Lukert and members of the Kansas Supreme Court. Ms. Lippert did a very thorough job. I'm not sure, and it sounds like the justices have reviewed the record. It is a rather extensive one by the time all the things are compiled, which is a pretty challenging process. I guess I maybe should adopt the procedure that that was used in the case last month. You may remember the pro se, it was a disciplinary case, the pro se respondent, his argument was, "I'm sorry." And that is true here, certainly, but I will try to direct the court to some additional matters that would need to be considered, or that I'm sure you will consider in a final decision here. I maybe just take a minute. Thought it might be somewhat interesting to everybody to share with you my involvement, initial involvement with the Supreme Court of Kansas. Occurred when I was in my first year of law school after having moved up to Topeka, and I had a 1-year-old son at that point, and I was taking him to Gage Park and was playing while he played. And after a little bit, a older woman looked at me and said, "Are you a law student?" I said, "Yes, I am." And she said, "Would you be interested in a job at the state Supreme Court Law Library?" And I said, "Yes, I would." Turned out that was Chief Justice Schroeder's administrative assistant. I think we called them secretaries back then. And I got to go to work at the Supreme Court Law Library for 2 years. Very interesting, a lot of fun. And then I got a job because I saw an ad in the paper. Got to go to work for Charles Scott, who was hearing officer for the Kansas Commission on Civil Rights, and has a very famous past with Brown versus Board of Education and the Scott family, Black lawyers. And I had the privilege of working with him. So I guess I meant to start this part out by commenting that I do, it is an honor and a privilege to appear before this court. I've done so in the past on a number of occasions before the Supreme Court and before the Court of Appeals, but it's been quite a while. So I am relishing this, although I don't particularly, I wish I wasn't having to deal with this issue for my longtime friend and associate, Mr. Leon. I've known him since he was, before he went to law school. And before that, I knew his father, who was confirmed with him, the first Hispanic lawyer, I believe, in the state of Kansas, Philip Leon. And I had the opportunity to work on some cases that he had forwarded to the office I was with, which was Ratner Law Office. And I could go into some story about that because Payne Ratner was a former governor, 2-term in the state of Kansas. But let me speed it up. There's one other thing I thought I would mention, which happened yesterday evening when I went to meet with a older client that I'm helping with some matters dealing with the death of her husband. And I mentioned that I was going to be doing this today. And she said, "Oh, I know somebody that I think was a justice." And after a minute or so, she said, "Lukert." And I said, "Yes, I know who that is." And he was on the Supreme Court, and before that, district court judge. And I had the opportunity during earlier years of my practice to try a number of jury trials in his court. So, all right, let me try to get down to the real substance here. And I'm going to let my client explain some things as far as where he's at on the steps he's taken and the steps he intends to take to try to come into full compliance. There are a lot of things that were mentioned, and I don't have the full story on the explanation. It is in the record. More detail about our explanation. I did not get involved in this case in the earliest part of it, and I think that's probably pretty standard. But certainly, I would say that we regret the manner in which the investigations occurred. And I would also point out, as you go through the record, or you've gone through the record, and we submitted response or our response to for the hearing panel after they conducted the hearing. And on page 10 of that document, 10 through page 14, it contains the our points about recommendations for mitigation. And I think if you will take a look at that, it will help explain what was going on and why, hopefully, that it would amount to mitigation that you should, consider. Among the things in there that I'll specifically mention at this point include letters of support from other members of the bar, including 2 district court judges here in Sedgwick County. Mr. Leon does have a rather interesting practice. He is has made and will continue to make some changes to make the practice more within what he can handle, but he handles a huge number of cases. He fills a gap for people who need representation, who are not in a position to pay the usual fees that criminal lawyers oftentimes charge. And he has a very capable staff of 3 people assisting him. He is going constantly, but he has recognized that needs to probably ramp down. I did get a call from Mark Bennett, the Sedgwick County District Attorney, maybe a couple of months ago now, informing me that David has 700 cases pending with the Sedgwick County Court. So that would give you a pretty good clue that he is a very busy person, and he is going. But one of the changes he is going to make, I'll let him explain that in more detail, is he's ramping down and going to limit what he will accept. And I think that will be very helpful. He has a lot of other attorneys that help him with his cases, that will make appearances, and he compensates them for that. We would strongly disagree with the recommendation from the disciplinary administrator for disbarment. And let's see, he should have done more sooner. I would not disagree with that, but the supportive letters that I mentioned do talk about the work that he does and the reputation he has with those judges and with other lawyers. I think I started to say I've known David since before he entered law school. I think he actually worked for me as a law clerk later when he was in law school for some period of the summer. So I guess I maybe will turn it over to him to make his response. And I guess I'll have to let him take this chair.
Thank you, Mr. Swenson.
Thank you, Honorable Justices. I know my time is very limited here, but I'm going to explain some of the response I heard. There was mention about a disciplinary matter that I had before which I entered into a diversion agreement completed back in 2012. Circumstance situation, I was representing a good friend of mine, and he was in a very difficult place in federal court. We worked out the best deal possibly could under the circumstance. Now, unbeknownst to me, we were looking at a case like State versus Merithi that would advise about the collateral impact you'd have in relation to what a conviction could have on your immigration status. And I advised my client that under Merithi, and that was the only guiding line at the time, Your Honor, I did advise him he had a right to trial, but he wanted to work out a deal, so I did. And as a result, Kentucky versus Padilla came down about 30, 45 days later, and as a result, he was subject to deportation. But that was not the prevailing law at the time, nor we knew that was going to come as about. So a couple years later, he hired another attorney, and I appeared in the federal court, Your Honor, and I testified to what the truth was at the point, and I took the diversion in order to resolve the issues that had been created as a result of my lack of knowledge about a case that had not existed at the time, and that was Kentucky versus Padilla. You know, since that time, I practiced with my father. We office shared for years. My brother was our accountant, our financial advisor. Unfortunately, about 2015, my father, my brother passed away, which took a real hit on everyone because he took care of all the books and everything. Then my father passed away roughly about 4 months later. It placed me in a bad situation. No excuse, I'm just telling you what happened. Placed me in a very bad position because, not only did I had to pay for 2 funerals I was not financially able to do at the time, I was also in a situation where, I'd lost my father who had been with me. He was my father, and he was also my office mate as well. And at that time, I didn't realize that he had allowed all his um, insurance policies to expire, but for one which barely paid for the funeral, but left me now in a situation where my mother had been, well, my understanding is my father had gotten a loan from a banker, which I used, the same at Community Bank of Wichita, where there was no insurance. And since I had my own obligation to it, I assumed that, so the responsibility wouldn't go against my mother. She would also lose her home and everything else. There was no savings or anything of that nature. Now, in regards to the other ones, I'm going to go as quick as I can because I know my time is limited. In my discussions with Mr. or TF, and that's one of the complaints, he filed that complaint while he was in custody. That was because Judge Kaufman would not allow him to get another chance at probation. Part of those funds were given to another attorney for her representation in an Oklahoma DUI down in Kake County, which we retained that individual with those monies, and she eventually brought that to its fruition, and she concluded that discussion. But the whole period of time, TF and I were discussing his cases in relation to all this. He told me that he felt bad that someone in the jail had told him to file a complaint, which he did. And I said, well, I can't get involved in that, but you need to convey that concern to the investigator once the investigator talks to you. But at that point, from then on, there was the complaint about the investigation. In one case, I did do the investigation, but I made full reimbursement to the client in relation to that, and allowed the statutory period of time to continue with that case to go. So it did not run on that individual. Now, in relation to the not following the no contact order, removing the no contact order, what I did on that case is that I advised my client repeatedly, both my client and his wife would call her once in a while. You have to, I know my relationship with the judge and how he sees things, that you're going to have to enter some kind of counseling or something like that. And she's going to have to contact the DA's office so they can communicate her intentions. That never came to fruition. And by the time the case had gone through its process, he had retained other counsel. And my understanding is that he resolved that case. But in any event, what we've done here, you don't know the level of remorse that I have in relation to all this, because I was placed in such a bad financial situation, not selfishly for my needs, but that for my family. I lost a home to a divorce. I needed to be in compliance with my custody of my children, everything. But since that time, I have reiterated my trust account with the Community Bank of Wichita that is now active. I have attained a professional, personal account, savings account with the Mid-American Credit Union. I also have a business expense account with the Mid-American Credit Union. The attorney-client fee agreement, that I admit that mistake of not taking out that paragraph when I had received a copy from another counsel. I didn't review it as quick as as thoroughly as I should have, but that was my fault, and I admit that. But that has subsequently been taken care of as well. I have been in complete contact with Bram and Danielle of the Kansas Lawyer Assistance Program to address the issues of this morning that I've never had an opportunity to address, and the burnout that I have, as well as the level of cases I've taken on. Once my father passed, I had to take over cases where I was totally not familiar with, in areas of immigration, in areas of domestic, and areas of civil, which I had to take and continue and get them resolved in exploration. I guesstimate I probably have represented thousands of people since I've been admitted to the bar back in '93. This is this period of time that I run into problems is all cultivated by family obligations. I understand that could be construed as being selfish needs. It wasn't a selfish need. I didn't want my mother to be homeless. I had to take care of my father's clients. I had to pay for my brother's funeral. I had to pay for my father's funeral. I had to maintain the obligations I have in my child support with my two former spouses. Everything hit me at once. And as a result, it's got me where I am today, which is all essentially my fault because I took that obligation. I have letters of good character from individuals who have dealt with me. Since I've practiced law, I've closed out the firms of at least four individuals who lost their license and one individual who passed away. And I took care of those free of charge. I did that as my obligation to the bar and to my community. I no one knows anything about me, but I do charge less than what most people do because I help people that are in a situation where they need my help. I always dedicate I'm bilingual and I dedicate my services to the bar free, the court's free because they ask somebody, can you interpret this for us real quick? Not in court because you have to have a court approved interpreter, but to help out. I always lend a hand to everyone, and that's probably been my biggest fault and my biggest weakness is my empathy and sympathy for other people. It's something that was drilled into me by my father, who I've never had an opportunity to address that. I've hid that I've hid that heart and hurt. I've never addressed my mourning over my father. And as a result, it's caused problems. I tried to keep living up to what he asked me to do. And that's to help those that can't help themselves. And I've just drawn myself ragged. And I've kind of come to a point where I asked for Caleb's help and they're with us. They're such nice people. And they deal with me all the time. When I talk to them and they send me to Impact for to get some counseling without necessary. And I've had a problem getting that done because they don't know where the funding's coming from. And I just got off the phone with them again today and I need help, but I can't afford it myself. But I'm gonna do the best I can. But and I just need to take my practice to a smaller level. I just want to handle traffic cases and misdemeanors. I don't want to convolute things any more than they have been. That's what I put up for the last 20 some years, and I just don't want to do it anymore. I just want to keep doing what my father asked me to, and that's to take care of people who can't defend themselves. And I have a niche in that. My clients are not my clients. My clients are poor, and I'm like a public defender who's not a public defender. I just help, and I feel very bad. I'm remorseful. I don't know what else I can say, other than the fact that I really put myself out there, and I did this to myself. But at the same time, there's reasons why, and I think it's because my father gave me too big of a heart. But I'm going to do the best I can, and if you just give me a chance to get in to do what I got to do, I'm going to go start. I want to start back small. I want to wrap it down, and I just want to move to a decent part of my life and to continue to serve the people that need my help. And at the same time, do what I can do. I can't respond. My slowness in the response was probably I was just so depressed at the time, and I have no excuse. This depression has got to me. But I do thank you for listening to me. All I can say is I'm sorry, but I'll keep trying to do my best. Thank you.
And I just have one follow-up sentence. David mentioned it. I forgot to mention it in my portion, but just to re-emphasize it, the assistance of KLAP has been wonderful, and they are super people, and highly commend them for what they do. So that concludes our presentation and our arguments.
Are there any questions for Mr. Swinson or Mr. Leon? Okay, thank you, counsel.
Thank you.
Ms. Lippert, you reserve 3 minutes.
Thank you. The respondent's bad faith obstruction, his failure to provide trust account or bank account records, his failure to make changes when he admitted to Investigator King that he was not compliant with rules, cannot be ignored. And it is particularly concerning that even after those acknowledgments, he still affirmed to the court in June of 2019, his attorney registration, that he was compliant with Rule 115. He was aware of, he was familiar with, and compliant with Rule 115, which is clearly contrary to the evidence. The victims were vulnerable. The respondent has substantial experience. And I would ask this court to adopt the hearing panel's findings of fact and conclusions of law, but find aggravating factors that support disbarment of the respondent in this case. That concludes, Your Honor.
Any other questions? Thank you to all of you for your arguments today. The court will take this matter under advisement. The court is now in recess until 9 a.m. tomorrow morning.